Well, I think we're all pleased to be able to meet in the flesh on this occasion. Before we embark on this marathon, there are one or two housekeeping matters that I'd like to raise with Council. Firstly, the written cases are so full that it can be a little bit difficult to keep track of what exactly the arguments are and where the relevant passages are to be found. It would be very helpful to the court if you were able to prepare a sort of Scott schedule which listed each of the issues that we have to determine, together with, in respect of each issue, the relevant passages in the judgments below and the relevant passages in your cases and supplementary cases.
Yes, we will do that. That sounds very sensible, if I may say so.
Yeah, we'd find that very helpful. Secondly, it struck us reading the cases that in relation particularly to the cross appeal, you'll need to bear in mind our authorities on the role of the board where there are concurrent findings of fact by the lower courts. The third point is our recollection is that on the last occasion there were transcripts prepared, and we were wondering if transcripts were being prepared on this occasion also.
They are, yes, so we can make sure those are made available.
Thank you, that'd be very helpful. And finally, we have had some problems with the electronic files, and we'll be in touch through the register. We'll be in touch with your instructing solicitors to ask for Word versions of some of the documents.
Yes, of course, we will provide those. Thank you.
Yes. Well, when you're ready, Mr. Smith.
Thank you. May it please your lordship, as previously I appeared together with Mr. Fisher and Mr. Amy for the appellant. My friends Mr. Gillis, Mr. Wilson, Mr. Brown and Mr. Gilson appear for the respondents. As your lordships will have seen, this is the hearing of the remaining parts of Primeo's appeal and also of the cross appeal made by the respondents. So far as Primeo's appeal is concerned, there's three issues that remain. The first is a point on contributory negligence. The second is a point on limitation. And then thirdly, there's a somewhat shorter point on the assessment of damages. Now, subject to your lordship, I was proposing to deal with those three issues in turn, starting therefore with contributory negligence.
Excuse me, may I just interrupt you for one moment?
Oh.
Hoping they could sort it out.
Yeah. You don't have a computer at all?
Been taken out of, the computer's had to be taken out of court to get sorted, so we better pause.
Yeah. You've probably overheard Lord
Yes.
Kitchen has a problem. He won't be able to access any authorities until his problem with the computer has been sorted out.
I do have the key document bundle.
Yes.
And I can obviously make use of that in the meantime.
I'm just
one minute.
Yes, we can make a version of the electronic bundle available if that would be of assistance. Mr. Fisher has a version on his laptop.
No, excuse me. Thank you very much for your
Thank you, my lord.
patients, and that has now been resolved.
Thank you. So, my lord, I was going to start then with contributory negligence. My lord, Primeo's claims against the respondents fall into two categories of contractual claim. Firstly, there's what we've called the strict liability claim against the second respondent, the former custodian, and that's not a claim to which contributory negligence applies. But secondly, there are also claims for damages for breaches of the custodian agreement and the administration agreement against both respondents. And I'll refer to those as the damages claims. Now, so far as the damages claims are concerned, the respondents pleaded and sought to rely on a defence of contributory negligence. That gives rise to the threshold question of whether the defence of contributory negligence applies to those claims at all. And so far as the applicability of the defence is concerned, there are two aspects, in short. The first is a question of principle as to whether Section 8, subsection 1 of the Cayman Torts Reform Act has any application at all to claims for breach of contract, such as a damages claim, including where there is concurrent liability in tort. We say it does not. That was a point which was not advanced in the courts below. It is, however, a pure point of construction as to the proper interpretation of Section 8.1 of the Act. The second aspect is that if we're wrong about that, and Section 8.1 does on its proper construction apply to contractual claims, at least where there is concurrent liability in tort, then we say Primeo's claims against the second respondent, its former custodian, fall into either Vesta Category 1 or Vesta Category 2, so that the defence of contributory negligence isn't in any event applicable. Now, on that point, as you may have seen, the judge at first instance held that the claims were within Vesta Category 1. The Court of Appeal, however, overturned him on that issue and held that the claims were in Vesta Category 3. We say that the judge was right, or alternatively, that the claims are within Vesta Category 2. So I was proposing to deal with those two aspects in turn, starting with the question of principle. Does the Act apply at all to contractual claims? In our submission, the starting point is to recognise that the ability to apportion damages where there has been contributory negligence derives solely from statute. It's effectively a statutory power which is conferred on the court. In the case of the Cayman Islands, the relevant statute, which is the source of that power, is Section 8.1 of the Torts Reform Act. The question whether that provides a right to apportion for contributory negligence in the case of a contractual claim arises, is simply a question of contractual interpretation as to whether Section 8.1 on its proper construction does apply in those circumstances. And indeed, it's common ground between the parties that this is an issue of the proper statutory construction of Section 8. Now, by way of background, Section 8 was originally enacted as part of the Cayman Law Reform Contributory Negligence Law in October 1964. If I could invite you, please, to go to page 9205 of the electronic bundle.
If you're going to have to wait a moment.
Yes, of course.
Sorry to be holding everybody up. I'm afraid mine won't open in the version I was looking at. I do have another copy of the folder saved to my laptop, and I'll just see if that one opens. I'm sorry, can you give me the page number again?
Yes, of course. It's 9205 of the electronic bundle.
Yes, I'm with you.
Thank you very much, my lord. So this is the 1964 Cayman Law Reform Contributory Negligence Law. And you will see in the middle of the page, section 3, subsection 1, deals with firstly, the removal of contributory negligence as a defence, and then secondly, the conferring of the right to apportion liability in case of contributory negligence. Now, section 3 is in the same terms as section 1 of the 1945 English Act. And you will also see just above section 3, there's a definition of fault, which is a key concept in understanding the section. Fault means negligence, breach of statutory duty, or other act or omission which gives rise to a liability in tort, or would, apart from this law, give rise to the defence of contributory negligence. Again, that was in the same terms as the definition in the 1945 English Act. And we'll obviously come back to how we say that is to be interpreted. If you just go over to 9206, please, you will see at the end of the law, there's what's called a memorandum of objects and reasons. And that stated that the object of this law is to permit a plaintiff to recover damages from a defendant, even though the negligence or other act or omission of the plaintiff giving rise to liability in tort has been either the decisive cause of the accident or so closely implicated with negligence of the defendant as to make it impossible to determine whose negligence was the decisive cause. So that gives you, in our submission, what the original intent was behind the law. And again, I'll come back to this point, but our submission is that the intent and purpose of the law was to remove contributory negligence as a complete defence in tort, particularly in the context of accidents. It was not to introduce and enable the apportionment of damages in relation to contractual claims. And one can see that in our submission from the memorandum of objects and reasons that accompanied the original 1964 law. Now, just to follow the legislative story forwards, the 1964 law was then reenacted in 1977 as part of the Torts Reform Law in 1977, and you can see that at 9515. So the Torts Reform Law was introduced in 1977. It was then revised again in 1996. And it consolidated the 1964 law, which we were just looking at, together with two other laws, the Fatal Accidents Law and the Law Reform Tortfeasors Law. So those were brought together into one statute. If you go to 9518, please. You will note in section 2 that the definition of fault was actually changed at this point. Now, just to clarify one point, there was an unfortunate typo within that definition. This was pointed out by the judge below. There is a missing word, or, which ought to appear between tort and which in the first line of that. So I think this is common ground. It's certainly what the judge found. How it should read is fault means an act creating a liability in tort, and then or which, prior to the operation of this law, would have given rise to the defence of contributory negligence. It's a slightly unfortunate typo because it does give a rather different sense to what it means. But for your lordship to note, it's paragraph 314 of the judge's judgment where he explains this point. As I say, the typo wasn't present in the original law in 1964 and appears to have occurred as part of the consolidation process in 1977. Now, leaving that point aside, in any event, you'll see that the definition now differs from that contained in the 1945 Act. If you go back to, if we stay on 9518, you'll see it now says an act creating a liability in tort, which prior to the operation of this law would have given rise to the defence of contributory negligence. Now, there's two changes from how the definition previously stood, and also, therefore, two changes from how it stands in the English Act. Firstly, the reference to negligence, breach of statutory duty, or other act or omission which gives rise to a liability in tort, has now simply been replaced with an act creating a liability in tort. And that's the first change. And the second change is that the words apart from this law have been replaced with prior to the operation of this law. Now, the 1977 law was a consolidation statute, and as the judge pointed out, it can't therefore have changed the law. But what it does show in our submission is that the draftsman and the Cayman legislature clearly understood that the concept of fault for these purposes was limited only to an act by the defendant which gave rise to a liability in tort. And that's obviously how the draftsman understood the Act when he effectively recast the definition, presumably in what he considered to be a simpler, perhaps more shorthand form, when the 1977 law came to be introduced. Now, if we go to section 8.1, you have the operative provision. This is page 9520 of the electronic bundle. And I was going to explain at the outset how we say section 8.1 falls to be construed. The first point to note in our submission is that section 8.1 is in two parts. The first part removes the defence of contributory negligence in respect of any claim which falls within the opening words of the subsection. So, in other words, where you have a case where a person has suffered damage, partly as a result of his own fault and partly of the fault of another person or persons, a claim in respect of that damage shall not be defeated by reason of the fault of the person suffering the damage. So that part of the subsection removes the operation of contributory negligence as a defence. It's effectively saying, well, that will no longer operate as a defence which defeats the claim. It's the language used in the subsection. Now, the second part, continuing on in subsection 1, then deals with the apportionment of damages. And the ability to apportion, as the language says, applies to damages recoverable in respect thereof. Now, the in respect thereof clearly relates in our submission to the claim which is the subject of the opening part of the subsection. So in other words, the claim in respect of the damage which results partly from the claimant's own fault and partly from the fault of the defendant. Now, it follows from this that really the key concept to understanding the scope and ambit of the section is the definition of fault. And if we go back to that, which is on 9518, you'll see, once it's read with the sense of the or which has been omitted, that it's used, the definition of fault essentially encompasses two concepts. The first is an act creating a liability in tort. And that is the concept which applies to the position of the plaintiff. And then secondly, the words or which prior to the operation of this law would have given rise to the defence of contributory negligence, and that applies to the position of, that applies to the position of the plaintiff. The opening words apply to the position of the defendant, and the second part applies to the position of the plaintiff. So there's two senses in which the concept of fault arises. The first is that you have an act creating a liability in tort. That's looking at the position of the defendant. The second is an act which prior to the operation of law would have given rise to the defence of contributory negligence. That's looking at the position of the plaintiff. So as I say, and I think this is common ground, the definition of fault essentially has two limbs. The first is concerned with the conduct of the defendant. The relevant fault of the defendant must be an act which gives rise to a liability in tort. And the second is concerned with the conduct of the plaintiff, and that must be such as would, but for the act, have given rise to the defence of contributory negligence. So you have the two concepts of fault bearing on the position of the plaintiff and on the position of the defendant. Now, that analysis, in other words, looking at the definition of fault as comprising those two limbs, is in our submission consistent with and supported by the approach of the House of Lords in the Standard Chartered Bank against Pakistan National Shipping Corporation case. And if I could invite you to turn that up, please, it's at page 6682. Now, the question before their lordships in this case was whether the defence of contributory negligence applied to an action in deceit. And it was held that since contributory negligence was not an action, was not a defence to an action in deceit at common law, the act was inapplicable. The facts are somewhat complicated. Essentially, it was a letter of credit case where the plaintiff bank, Standard Chartered, had confirmed a letter of credit and was induced to make payment against a falsely backdated bill of lading produced by the seller of the cargo, the shipping agent and the ship owners. So there was a clear deceit practiced on the confirming bank, and it was held that the seller, the agent and the ship owners were guilty of deceit. But the question was whether the plaintiff bank, Standard Chartered, was to any extent guilty of causing its own loss by having paid out on the letter of credit, having overlooked other discrepancies in the documents, which would have entitled it to refuse payment. So essentially, as you can see, an issue of contributory negligence, whether contributory negligence had any relevance at all in that context. Now, the speech in the case, the judgment in the case was given by Lord Hoffman, and his analysis on this point begins at paragraph 11 on page 6688. And if we just pick it up at paragraph 11, he begins by considering the definition of fault, which we have just been looking at. He says, in my opinion, the definition of fault is divided into two limbs, one of which is applicable to defendants, the other to plaintiffs. In the case of a defendant, fault means negligence, breach of statutory duty or other act or omission which gives rise to a liability in tort. In the case of a plaintiff, it means negligence, breach of statutory duty or other act or omission which gives rise at common law to a defence of contributory negligence. So that's making the point I was endeavouring to make a moment ago, that you look at the definition as comprising those two limbs, one of which applies to defendants, one of which applies to plaintiffs. I should say, just for your Lordship's note, that that way of analysing the definition of fault is also consistent with the way the Australian High Court looked at the point in Astley against Austrust. It's page 767 to page 768, and again at page 771. We're going to come to Astley and Austrust in a moment, but I interpose just to make that point here. Now, he then goes on from that starting point in paragraph 12 to focus on conduct by the plaintiff. And he says it follows that conduct by a plaintiff cannot be fault within the meaning of the Act unless it gives rise to a defence of contributory negligence at common law. This appears to me to be in accordance with the purpose of the Act, which was to relieve plaintiffs whose actions would previously have failed and not to reduce the damages which previously would have been awarded against defendants. So in other words, in order for fault of the plaintiff to qualify, it has to be of a type which would, but for the law, have given rise to a defence of contributory negligence at common law. That is the qualifying characteristic, if I can call it such, which identifies what is relevant conduct of the plaintiff for these purposes. And then if we go over to 6689, he then applies that analysis to the actual issue on the facts in that case, and says at the start of paragraph 13, the question is therefore whether at common law, Standard Chartered Bank conduct would be a defence to its claim for deceit. And there's some analysis, some discussion following that, where he deals with the question of contributory negligence, the extent to which it is a defence at common law to deceit, and the extent to which it is at common law a defence to a claim for negligent misstatement. Now, in our submission, one point that's important to note about Standard Chartered is that the false representation made by the ship owners, shipping agent and managing agent of the seller would presumably also have given rise to liability and negligence for negligent misstatement. The claim was obviously put as one of deceit, but there's no reason why it couldn't also, it seems, have been put as a claim for negligent misstatement as well. Now, as Lord Hoffman pointed out in paragraph 17, contributory negligence might well have been a defence to such an action. He refers in paragraph 17 to the Gran Galato decision, which makes the point that a defence of contributory negligence, it said, would be available to a claim for damages under section 2.1. Gran Galato also makes the point that a defence of contributory negligence would be available to a claim for negligent misstatement as well. That's page 572G of Gran Galato. But the fact that contributory negligence may have been a defence to an action for negligent misstatement in respect to the representations didn't mean it was a defence to an action in deceit. Because he then goes on, as you can see in paragraph 18. In fact, if we pick it up at the end of paragraph 17, he reaches a conclusion that there is the possibility that in the case of an innocent representation, which would include a negligent one, some other kind of negligent causative conduct might be taken into account. So in other words, you might have a defence of contributory negligence for a negligent misstatement action. But then he goes on in paragraph 18 to say, well, that really is by the by, because this is a case of fraudulent misrepresentation. And I agree with Mr. Justice Mummery in the Edgestop case that there is no common law defence of contributory negligence to an action in deceit. And then ultimately the conclusion at the end of paragraph 18, it follows that in agreement with the majority in the Court of Appeal, I think that no apportionment under the 1945 Act is possible. Now, what in our submission this shows is that what matters for these purposes is whether contributory negligence was a defence to the legal claim in respect of which apportionment is sought. It's not sufficient that contributory negligence might have been a defence to some other claim in respect of the same conduct. If that had been the position, Lord Hoffman's analysis would have proceeded on a completely different basis, because he would have asked himself, well, is contributory negligence a defence to any other cause of action in respect of these misstatements, including, for example, negligent misstatements of common law? And if it is, does that mean that the right to apportion applies? But that plainly isn't the analysis. What the focus is on the actual cause of action in respect of which apportionment is claimed. In that case, it was a cause of action in deceit. And the inquiry is simply whether, in respect of that cause of action, at common law, there would have been a defence available of contributory negligence. Now, that takes one then to the next point, which is that the fundamental question then becomes, what was the position at common law, but for the enactment of the Law Reform Contributory Negligence Act? And in our submission, and on this we obviously rely on the Australian High Court, contributory negligence was never a defence at common law to a claim for damages for breach of contract. There's a faint suggestion to the contrary in the respondent's case, written case. I'll come back to that. But in our submission, it's quite clear from both what the Australian High Court said in Astley and Austrust, and also from the various legal commentators who've looked at this issue, that prior to the Act, contributory negligence was not a defence to a claim in contract, including where there was concurrent liability in tort. Now, if we're right about that, and one goes back to Section 8.1, then the opening part of Section 8.1 doesn't apply to claims for breach of contract, since they're not claims in respect of damage which was partly caused by the, quote, fault, unquote, of the plaintiff. Because the conduct of the plaintiff in relation to a claim for breach of contract is not conduct which prior to the operation of this law would have given rise to the defence of contributory negligence. Now, just to deal with one point at this stage, if you turn back to the definition of fault on 9518, and I'm not sure whether this is a point which is advanced by the respondents in this case, but if you focus on the wording dealing with the relevant conduct of the plaintiff, in other words, the wording which prior to the operation of this law would have given rise to defence of contributory negligence, it has been suggested that a possible reading of that wording is that it's sufficient that the Plaintiffs' Act would have given rise to a defence in contributory negligence in respect of some other cause of action in relation to the relevant conduct, even if it's not the cause of action actually being asserted and in respect of which apportionment is sought. So in other words, the argument would be, well, where you have a claim for damages for breach of contract, it would go, well, it doesn't matter that contributory negligence was not a defence to a claim for breach of contract if the claim could also be framed as one in negligence, because contributory negligence would be a defence to a negligence claim. So in other words, the argument would say, well, you don't need to look at the actual cause of action being asserted. You simply look at the conduct and ask yourself, well, is the conduct such that it might, if the claim had been put in a different way, give rise to a defence of contributory negligence? Now, in our submission, that argument is inconsistent and incompatible with the Standard Chartered Bank case and the analysis we've just been through. Because if that argument is right, the analysis in the Standard Chartered Bank case would have had to have asked, do the relevant misstatements also potentially give rise to a cause of action in negligent misstatement at common law? And if they do, well, contributory negligence would be available as a defence, because contributory negligence was, and indeed is, available as a defence to an action in tort for negligent misstatement. That's Grangolato makes that clear. It would also mean that contributory negligence would apply to any cause of action at all where the relevant claim was capable of being framed in the alternative as a claim to which contributory negligence had been a defence. So it would potentially actually apply to actions in deceit, or indeed any other claim at all where the relevant underlying act is capable of being characterised as one giving rise to liability in negligence. Now, in our submission, that's the wrong approach. It's inconsistent with Standard Chartered Bank. It's inconsistent with Astley and Austrust. It doesn't find support in the language of the statute. And it leads to the surprising consequence, as I say, that contributory negligence would be available to any claim of any type, depending on the ability to recharacterise the conduct as also potentially giving rise to a claim in negligence. Now, once that argument is rejected, then the question simply is whether contributory negligence would have been a defence prior to the Act in relation to the cause of action in respect of which apportionment is sought. Now, we would also suggest that way of looking at it is consistent with the purpose, certainly of the English Act. If we go back to paragraph 12 of Standard Chartered Bank, just to look again at what the House of Lords said about the purpose, this is 6688. As part of his analysis in paragraph 12, Lord Hoffman analyses the text, but then he says this in the second sentence of paragraph 12, this appears to me in accordance with the purpose of the Act, which was to relieve plaintiffs whose actions would previously have failed, and not to reduce damages which previously would have been awarded against defendants. Now that's, in our submission, very important, because the purpose of the Act fundamentally was to remove the ability of defendants to assert contributory negligence as a defence. The right to apportion, if you like, is ancillary to that. You see that in the language of the subsection. It wasn't, as he says, to reduce damages which previously would have been awarded. Now, if it's right, and we say it is, that contributory negligence was never a defence to a contractual damages claim at common law, one has to ask oneself, well, how is it consistent with that purpose? that the effect of the Act is to reduce damages for breach of contract, when that would never have been the position at common law. That is contrary to, in our submission, what is clearly the purpose of this legislation, which was to remove the ability to rely on contributory negligence as a defence to actions where it was a defence, which were essentially actions in tort. Now, just before we come to the case law, just the other point, just to emphasise on construction, whilst we're there, if you go back to the definition of fault, please, in the Law Reform Torts Act, which is, I think, 9518. It is also telling in our submission that when one is looking at the relevant conduct of the defendant, that is framed specifically by reference to an act creating a liability in tort. That's what it says expressly. It obviously doesn't refer to a liability in contract. Now, it's an obvious point that one, in my submission, is entitled to ask the question, well, if this had been intended to apply to a contractual liability of the defendant, why didn't it say so? Why does it just refer to a liability in tort? And that is a point which applies with greater force, I might say, in relation to the Cayman statute than it does even in relation to the English statute and the Australian statute, because the Cayman statute, since 1977, has had this slightly different definition of fault, which focuses very specifically on an act creating a liability in tort in relation to the relevant act of the defendant. So that's how we say it's to be construed. Essentially, the question you have to ask is very straightforward. You look at the conduct of the plaintiff, you look at the cause of action that's been asserted, you ask yourself, what was the position at common law? At common law, would this conduct have given rise to a defence in contributory negligence, which would have defeated the claim? If you have a contractual cause of action, the answer to that is no. Therefore, the act and the right to apportion isn't applicable and isn't relevant. Now, so far as case law is concerned...
Well, sorry, just before we move on from Section 8, which is page 9520.
Yes.
Section 8.1. I mean, I suppose you could say that the natural reading of that is that there's a straight substitution of what was a complete defence of contributory negligence, where it says... a claim in respect to that damage shall not be defeated by reason of the fault of the person suffering the damage, but the damages recoverable shall be reduced to such extent. And presumably you do say that, that it's a straight substitution where there was a complete defence before. Now there's a balancing defence.
Exactly. So we would respectfully agree with that. And it's effectively removing the absolute defence, taking that away, but saying as the quid pro quo for that, there is this right to apportion. And that's why I say the right to apportion is ancillary to the opening part of Section 8.1. It's effectively ancillary to the removal of the defence. If you like, it's the quid pro quo. And that, of course, chimes with what Lord Hoffman said about the purpose of this section, which is effectively to increase the rights of plaintiffs and not to reduce them. Now, so far as the case law is concerned, there is no existing Cayman law authority on the interpretation of Section 8. Aside from the two judgments below in the present proceedings, we've not been able to find any existing Cayman authority at all, which even makes reference to Vesta and Butcher. So,
I'm sorry, I'm just pursuing the train of thought that Lord Sales has triggered. So in Section 8.1, the whole premise of Section 8.1 is that a claim in respect of the damage would before this legislation have been defeated.
Exactly.
And I suppose if you're going to tell us that a claim in contract could not be defeated by reason of the fault of the person suffering the damage, then we'll have to look at what the reasoning was for contributory negligence being a defence in tort, and look at why that reasoning was incapable of applying to a contractual claim.
Yes, quite. And I think I'll come to it, but I think a convenient place to pick that up is probably the exercise the Australian High Court went through in Astley and Ostrust, because they looked at this in quite some detail, in part by reference to the old forms of action, and simply the different way in which an action in tort and an action in contract had to be pleaded. But yeah, certainly I'm going to come to that, because in our submission that is actually then the critical question. Yeah. Now, so far as case law is concerned, effectively Cayman is really a blank canvas on this point. So far as other common law jurisdictions are concerned, there obviously are authorities dealing with the construction of similar provisions in their legislation. Those include clearly the decision of the Court of Appeal and Mr. Justice Hobhouse in Vester and Butcher as a matter of English law. There's also the decision of the Australian High Court in Astley against Austrust, and also the decisions of the New Zealand courts, which have looked at effectively the equivalent provisions in New Zealand. Now, it's fair to say, I think those decisions show three different approaches to the question of interpretation. There's the Vester classification approach from Mr. Justice Hobhouse. There's the Australian approach, which effectively says it doesn't apply at all to contractual claims. There's the New Zealand approach, which I think probably goes even further than Mr. Justice Hobhouse in the other direction and says it applies to any claim which involves anything that might be described as negligence, whatever the source of the cause of action. Now, our position is that the interpretation explained by the Australian High Court in Astley and Austrust is the correct way to interpret Section 8.1. Now, if we could go please to Astley and Austrust, it's page 2999 of the bundle. And the relevant part for our purposes, you see picked up in the head note, just at the very bottom of the right-hand side column on page 2999. It's item 4 of the head note. And you'll see this was effectively a 4-1 decision of the Australian High Court on this point, Justice Callanan dissenting. Contributory negligence is not a defence to an action in contract at common law and does not give rise to apportionment of liability under the apportionment legislation, even where, as here, the contractual duty is concurrent with a duty in the tort of negligence. And you'll see there's then a raft of authority which they considered in coming to that point, including Vester and Butcher. Now, the actual legislation which was at issue in Astley was Section 27A of the South Australian Wrongs Act of 1936. If you go to page 3008, you can see the text of that set out in the judgment of Chief Justice Gleeson. And the relevant parts, firstly, the definition of fault within subsection 1. And then secondly, the substantive provision in subsection 3.
Can I just check? This is section 27, capital A.
Yes.
So presumably this is a section which is added after 1936.
Correct.
Do we know when it's?
I don't know off the top of my head. We'll find that out. It must have been added after the English 1945 Act, but we will check the exact date.
Right. Yeah. Thanks.
And we'll come to it in a moment, but it was clearly inspired by the English 1945 Act because the Australian High Court referred to the same Law Review Committee report which preceded the 1945 English Act. But just to show you this, and the point just to make is obviously the legislation is essentially the same as the English Act. It's essentially the same as the Cayman Act, save for the difference in the definition of fault, which was changed in the Cayman Islands in 1977, as we've already seen. Now, just to pick up the relevant parts of the judgment of Chief Justice Gleeson, if we could go first to page 768, which is 3099. On the left-hand side, about 2/3 of the way down, he deals first of all with what he considers to be the natural and ordinary meaning of the statutory provision. He says...
So, forgive me, the page again, please.
It's 3009.
3009, yes, thank you very much.
Page 768.
Thank you.
And just to go firstly to the left-hand column, about 2/3 of the way down, there's a paragraph beginning the natural and ordinary meaning. And he deals there with his impression of simply reading the statute. He says the natural and ordinary meaning of section 27A3, read in the light of the definitions contained in the section, indicates that the section is concerned with claims in tort rather than claims in contract. The subsection was designed to remedy the evil that the negligence of a plaintiff, no matter how small, which contributed to the suffering of damage, defeated any action in tort in respect of that damage. Nothing in section 27A3 suggests that fault in either of its uses, section 27A3, includes rights and obligations arising from a breach of contract, nor is there anything in the ordinary and natural meaning of the section that can be said to assume or by necessary implication authorise the apportionment of damages in claims for breach of contract on its face. Section 27A deals only with actions in tort. So that, if you like, is his initial view on reading the legislation itself. There's then a section which I don't think matters for present purposes, where he deals with concurrent liability and the question of whether there can be concurrent liability at all. That doesn't matter because they conclude that there is. But if we go to page 770, 3011 of the bundle, towards the end of the left-hand column, he starts to grapple further with the question of whether the Wrongs Act applies to an action for breach of contract. He says, despite the textual indications and the historical reasoning, the historical reasons that point to the section being unconcerned with contractual claims, it is argued that it does apply to case of breach of contract, at least where there's concurrent liability. And he says the solicitors in that case rely on a number of authorities which hold that it applies to breach of contract, damages claims, but there are also cases to the contrary. And there's then a section that deals with some preceding Australian cases. But if we go on to 771, in the right-hand column, at the bottom of the page, he then deals with a New Zealand case called Rowe against Turner, Hopkins and Partners. Now, the New Zealand case is important because the judge in New Zealand held that the New Zealand legislation did apply to claims for breaches of contract, at least where there was concurrent liability. And that case was then subsequently referred to by the English Court of Appeal, in particular in Vester and Butcher. So he deals with this at beginning on page 771 towards the end of the right-hand column. And effectively, if we go over to 3013, he criticises the conclusion that the New Zealand judge, Mr. Justice Pritchard, reached in that case. And having set out quite a lengthy passage from the judgment, he then makes, I think, 5 points. The first of these one sees on page 772 in the left-hand column immediately following the quote. He says that the conclusion is surprising that the plaintiff's damages for breach of contract are reduced merely because the defendant is also liable in tort. So he regards.
What are you reading?
So I'm on page 3013, with page 772, and then in the left-hand column, he sets out a quite lengthy quote from Mr. Justice Pritchard, and then there's a paragraph beginning towards the end of the column on this reasoning.
Yes.
So this, as I read it, is the first of his points he makes, effectively critiquing that conclusion. And the first point is to say, well, it's surprising that the plaintiff's damages in contract are liable to be reduced merely because the defendant is liable in tort. And in our submission, there is considerable force in that. One asks oneself, well, why is it that damages in contract should be reduced merely because there is concurrent liability? Effectively, the point is, well, if there wasn't concurrent liability and merely a claim for breach of contract, there wouldn't be a reduction for contributory negligence. The only reason there's a reduction for contributory negligence is because there's also concurrent liability. And why is it that the fact that the defendant is also liable in tort means that the contractual damages claim should be reduced? And putting it slightly glibly, the more duties a defendant breaches, the better off he is on this analysis. And that is a slightly glib way of putting it, I accept, but that reflects, I think, the sentiment underlying why he regards that as a surprising starting point. Now, the second point, then, at the top of 3013, is that he notes that Mr. Justice Pritchard had accepted, in our submission rightly, that the fault of the plaintiff was never a defence to an action for breach of contract. So in relation to the common law position, Mr. Justice Pritchard had accepted that the contributory negligence wasn't a defence to an action for damages for breach of contract. And therefore, he says, well, it follows from that the jurisdiction to apportion, the direction to apportion, simply isn't applicable. Once one reaches the conclusion, as the judge did in New Zealand, that the contributory negligence wasn't a defence at common law, well, there isn't any basis for then seeking to invoke the statutory power to apportion. The statutory power to apportion only kicks in relation to a claim where contributory negligence had been a defence at common law and where the statute operated to remove that defence.
Yes, as I read that first paragraph at the right-hand column, in substance, it's what I was putting to you, that the substantive predicate for the power to apportion is that there would have been a complete defence to start with.
Exactly.
And it's the apportionment is a substitution for that complete defence. If no complete defence in contract, the predicate just doesn't apply in a contract case.
Exactly. We respectfully agree with that. And it is quite interesting to note, though, just on the point we will come to in a moment, that Mr. Justice Pritchard in the New Zealand case had accepted, we say rightly, that contributory negligence wasn't a defence to a contractual claim at common law. And we'll come to...
The respondent's answer is that concurrent liability in contract and tort wasn't recognised until after the 1945 Act had been enacted. Obviously, there's an issue as to whether that is in itself gets you anywhere, gets them anywhere. But if it could, in principle, get them anywhere, there's then a further issue as to whether, assuming that concurrent liability had been recognised, would contributory negligence, would the reasoning which led to the claim, the liability in tort being rejected by reason of contributory negligence also have led to the rejection of a claim based on concurrent contractual liability?
Exactly. And I mean, in our submission, not. And the reason for that is fundamentally they are, I mean, although one speaks of concurrent liability, fundamentally one's talking about two different claims. I mean, there is a claim in contract and a claim in tort. There isn't a cause of action in concurrent liability, as your lordships know. And therefore, you do need to look at the position in relation to each claim. Astley and Ostrus was a case of concurrent liability. And as the Australian High Court explained, contributory negligence wasn't a defence to the contractual claim. So whatever the position in relation to the tortious claim, it isn't a defence to the contractual claim. Now, if one accepts that, then one is simply into a question of interpretation of Section 8.1. And in our submission, it's a condition to the application of the apportionment power that it must have been a defence to the relevant cause of action at common law. So it's essentially those, if you like, the two ingredients to the analysis. Now,
in another complication is that one approach, I think one respondents adopt, would be to say that, looking at it the way in which the High Court of Australia looked at it, one approach would be to say that if you were dealing with a contractual situation, then contributory negligence couldn't arise as a matter of law because the promisee is entitled to rely on the promise that's been made, and it doesn't have to. As a matter of law, it's under no obligation to check that the other party is actually fulfilling its promise.
yes.
Another possible way of looking at it would be to say that the existence of the contract makes a difference on the facts of the situation. That whether, as a matter of fact, it should be regarded as contributory negligence to fail to check what the counterparty is, that the counterparty is performing its obligations properly, might be affected by the existence of the promise to have done so.
Yes, I mean, I certainly agree that, with respect, that I mean that was capable of being an issue on the facts. In other words, it was capable of, assuming contributory negligence applies to contractual claims, and the existence of the contract is plainly capable of being a factor that is relevant to whether or not there is contributory negligence on the facts. But I mean, obviously, I'm just concerned at the moment with the sort of prior question of whether we get there at all. And I mean, fundamentally, the two building blocks in my analysis are: you start with Section 8.1, ask oneself, well, what's the precondition to the invocation of the apportionment power? Well, you need a cause of action in respect of which contributory negligence would have been a defence in common law. That's building block 1. And building block 2 is, well, contributory negligence wasn't a defence at common law to a claim for breach of contract, including where there was also a liability in tort. Now, I mean, just going back to where we got to with Chief Justice Gleeson, where he's effectively set out the view of Mr. Justice Pritchard to the contrary, and then he's critiquing that. We just went through what I think was his second point at the top of the right-hand column on page 772. Immediately following that, he makes a third point, which is effectively to say that Mr. Justice Pritchard seems to have assumed that the principle of apportionment is paramount and that legislation was intended to require that damages be apportioned in all contract cases where a liability in tort also exists. And he says this assumption is inconsistent with the history of legislation, whose purpose was to enable recovery of damages by plaintiffs in cases where their contributory negligence would have meant they recover nothing. The section was designed to increase the rights of plaintiffs, not to reduce them. As I read it, he's effectively saying, well, Mr. Justice Pritchard seems to proceed from an assumption that apportionment should apply. His point is to say, well, there's simply no basis for that assumption. The fourth point he then makes in the next paragraph is to say that the assumption also overlooks the fact that contractual damages may be different from those in tort. Nothing in the legislation gives any hint that it seeks to regulate award of damages in contractual cases. Moreover, the assumption that the two causes of action are effectively merged does not accord with the attitude of the courts in relation to the differences between bringing an action in both tort and contract. And he refers to the fact that there may be different limitation positions in relation to the contractual claim and the tortious claim. And we respectfully endorse that point. I mean, there is, I think, a tendency in some of the cases to treat concurrent liability almost as if it was a cause of action in its own right. And the cases talk of concurrent liability owed by the defendant to the plaintiff, but that obscures the fact that in the case of concurrent liability, there are separate and distinct causes of action in contract and tort. And then fifthly, he then says, I think this is perhaps then going back to his earlier point, there's nothing in the legislation which suggests that the Wrongs Act intends to limit recovery of damages by plaintiffs in contract to the amount allowable under the apportionment section. Now, he then deals with Vester and Butcher, beginning just following the section we were looking at. If we go to 3014, he comments at the bottom of the left-hand column by reference to the decision of the Court of Appeal. The reasoning of the majority in the Court of Appeal, like that of Pritchard in Roe, assumes that if an action can be brought in tort, that is sufficient for the application of the apportionment legislation to a claim in contract. So he's identified that as the assumption underlying the reasoning. And of course, he criticised that as being ill-founded. We say he was right. There then follows a treatment of some Australian cases which had followed Vester and Butcher. And at 3015, page 774, he effectively says that those decisions shouldn't be followed. If we pick it up halfway down the left-hand column on 774, he says, in our opinion, the case law in this area is unsatisfactory. It displays substantial flaws of reasoning and is overall in a state of confusion. Furthermore, the tripartite division adopted by the United Kingdom case is unacceptable. Now, that's a reference to the Vester and Butcher classification. The legislation does not hint at such a distinction. And then he quotes from Justice LaForest, and then goes on, in our opinion, those decisions which have applied apportionment legislation based on the Law Reform Contributory Negligence Act 1945 to breach of contract are wrong, should not be followed in this country. The interpretation of legislation adopted by those courts which have applied the legislation to contract claims is strained, to say the least. And then he says it relies principally, if not exclusively, on the term negligence and the definition of fault. Now, we'll come back to that point, but that of course, is a point that doesn't apply to the Cayman legislation, because the word negligence was actually removed from the definition of fault, as we've seen. Now, there's then a section in the right-hand column, 774, where he reverts to the construction of section 27A. He says the construction of statutes is not an exact science. In many cases, every argument in favour of a particular construction can be met with a plausible counter-argument. But so far as issues of statutory construction go, on any fair reading of the apportionment legislation, against the background of the mischief it was intended to remedy, it's clear to the point of near certainty that the legislation does not and was never intended to apply to contractual claims. And then there's some contractual points, some contextual points about the legislation, which we will come back to. But just picking up the debate we were having a moment ago, on page 775, 3016, beginning in the left-hand column, in the penultimate paragraph, there is a section which in our submission conclusively demonstrates that contributory negligence was never a defence at common law to a claiming contract. And this is obviously a section of the judgment which in our submission repays careful reading. But he sets out, beginning at page 775 in the left-hand column, the history of the defence of contributory negligence, which he says was invented in 1808 as an answer to an action in nuisance. No case can be found in the books where contributory negligence as such was ever held to be a defence to an action for breach of contract.
Before we get to that, there's perhaps a significant passage on the previous page.
Yes.
It's 3015, the right-hand column,
yes,
where he quotes the definition, the same as the UK definition of fault, I think.
Yes.
Negligence, breach of statutory duty or other act, etc. And he says, he deals with the argument that negligence is negligence at large,
yes, potentially
contractual, and not limited by the words further on in the definition, which gives rise to a liability in tort.
Yes.
And points out that if that were right, then breach of statutory duty would equally be unconfined.
Yes. No, absolutely. And I mean, in our submission, he's almost certainly right about that. I mean, perhaps if I can just bring up for a second the definition of fault as it appears in the English Act, which is 9200. So your Lordship's absolutely right. The argument he's dealing with is that when you see the reference to negligence, where it appears first in the definition, you can read that, in effect, independently from the subsequent wording gives rise to a liability in tort. So the argument is, well, you just look at negligence, and you can look at that in isolation, and that's capable of encompassing a negligent breach of contract. Now, he rejects that argument. In my submission, he's right to do so, because if you look at the language as a whole, and also the history and the context of the legislation, it's clearly concerned with tort claims. But also, it's not actually a point that engages with the Cayman statute, funnily enough, because what we know is the draftsman in 1977 changed the definition of fault in the Cayman Islands, and he clearly understood that when it referred to negligence, it did mean negligence giving rise to a liability in tort, because that's why he then replaced it with the short form phrase, an act giving rise to a liability in tort. So actually, this argument about negligence is not, the meaning of that word is not only wrong in our submission, but it doesn't actually engage with the Cayman statute. But it is an important point, because your Lordship, if I may say so, is right to pick it up, because when you come to the New Zealand cases in particular, they rely to a lesser or greater extent on that way of reading negligence, which we would say is A, wrong, B, doesn't help with the Cayman statute.
Could I just check one slightly different point? 1945 Act, we're talking about that. Presumably, there wasn't a transition provision, so it just applied from the date that it came into force to any cause of action which had accrued before that time, which happened to be vindicated in litigation afterwards.
I believe so, yes. I believe that's right.
So I just wonder whether there is an additional point that in effect, people had accrued causes of action in contract, which were capable of being vindicated without any defence of contributory negligence or reduction of damages on account of contributory negligence. And to construe, I mean, clearly the tort position is affected by the clear language of, I'm mixing up my statutes now, section 8.1 because it's in my head. But I just wonder whether it might be said that as a pointer against that applying to contract, where it doesn't refer to contract, is that it would have, such an interpretation would have taken away already accrued rights at that time, which would be perhaps surprising.
Yes, I mean, that must be right if if the respondent's construction of the legislation is right, which
All right, thank you.
would be surprising. I mean, just going back to, I think we were 3016, and just on the section we were looking at, which is effectively the historical position. I mean, he makes a number of points in this passage, one of which is the absence of any reference in any of the cases to contributory negligence being a defence to a claim for breach of contract. He also makes the point, well, none of the works on pleading from the 19th century make any mention of it. No trace of a defence can be found in any of those works. And then there's a section that follows, which I'm not going to have time to read out, but it is, in our submission, important because he explains as a matter of pleading by reference to the old forms of action in assumpsit and non-assumpsit why contributory negligence could never have been a defence. And he says, just picking it up, 775, right-hand column, beginning of the final paragraph there, the reason why it would never have occurred to the common law lawyers to plead such a defence is not hard to find, and then it explains why. Now, just going over to 776, 3017, top of the left-hand column, he says the proposition that prior to the enactment of that legislation, contributory negligence operated as a defence to a breach of contract relies principally on Professor Glanville-Williams' thesis in joint torts and contributory negligence, and that is indeed what the respondents rely on primarily before your lordships. But he then deals with that. He says it can't seriously be maintained in the face of any lack of any suggestion in any contract case or work of pleading that the principle of contributory negligence is or ever was a defence to a claim for breach of contract. Professor James Swanton notes it was never clearly established whether contributory negligence was a defence at common law to actions for breach of contract, though Professor Glanville-Williams argues that it was. He is not prepared to assert that it was a defence eo nomine, so by that name. The fact that contributory negligence was not a defence to an action in contract points irresistibly to the conclusion that the apportionment legislation is concerned only with actions in tort and does not affect awards of damages based on breach of contract. And then he goes on, the final paragraph, the purpose of the enactment of the apportionment legislation was to allow recovery of damages in cases where contributory negligence would defeat an action in tort. Now, there's then a section that follows where he refers to the report of the English Law Revision Committee, which preceded the 1945 English Act. We also rely on that. We've set out some of the relevant passages in our written case, but it does, in our submission, show that the intended purpose and scope of the 1945 Act was to deal with actions in tort, and principally what they were concerned with was road accidents and similar tortious claims.
Mr. Smith, I'm very sorry. I've got a technical problem.
Oh.
My computer's not been getting power and has shut down. So I don't know if
Yes, I have the same problem.
I thought it was all plugged in, but it doesn't seem to be working.
No, there seems to be an issue with the wiring here. Well, I think I think it might be better if we were to adjourn for 5 or 10 minutes until it's sorted out. Well, my apologies for that interruption. I trust everything will work all right now. So, Mr. Smith.
Thank you very much, my Lord. My Lord, I was just coming to the end of the Australian case, and unsurprisingly, our essential submission is that the construction adopted by the Australian High Court of the Wrongs Act in that case was correct for the reasons given by the High Court, and we say the same reasoning and interpretation applies to Section 8.1 of the Cayman Statute. Moreover, that reasoning and interpretation takes into account both Vesta and Butcher, and also the New Zealand decision of Mr. Justice Pritchard in Roe, Turner, Hopkins and Partners. Now, my Lord, just one point to deal with is it is the case that the effect of Astley and Austrust was subsequently reversed in Australia by legislation, and we've set out in our written case the references to the various state legislation. Under that legislation, contributory negligence is now available as a defence to all claims for damages for breach of a contractual duty, where it is both concurrent and coextensive with a duty of care in tort. But in our submission, that simply tends to confirm the point that under the original legislation, as properly construed, it wasn't so available. My Lord, I was just going to go on then to the position in New Zealand. Before I do so, just 2 points just to pick up from this morning. My Lord Sales asked about the position in relation to transitional provisions in the 1945 Act. I think what I said was actually wrong, because if you go to page 9199, there is indeed a saving provision in subsection 2 of section 3. This act shall not apply to any case where the acts or omissions giving rise to the claim occurred before the passing of this act. So they had indeed covered that off. There is a transitional provision dealing with that. So I don't think I can advance the point we were discussing before the break. The second point in relation to Astley and Austrust, the amendment to the Wrongs Act was enacted in 1951. By the Wrongs Act Amendment Act 1951, so it came into place roughly 6 years after the English legislation. Now, so far as New Zealand is concerned, I'm going to deal with that quite briefly because we've already looked at it to some extent in the context of the Australian Act. The first case is Roe against Turner Hopkins, the Justice Pritchard decision, which is at 6459. And again, this was dealing with a similarly worded statute, on this occasion Section 3 of the New Zealand Contributory Negligence Act 1947. And the judge dealt with the construction issue at 6464, which is page 555 of the report. And if we pick it up just underneath line 15 on the left-hand side, he begins by making the same point we've seen in a number of cases, that the word fault really has two contexts or limbs. Firstly, referring to the act or omission of the plaintiff. Secondly, referring to the act or omission of the defendant, which gives rise to the plaintiff's cause of action. And then he refers to the position of the plaintiff. And then at line 25, deals with the position of the defendant. Of more immediate concern is the meaning to be given to the word fault when used with reference to the conduct of the defendant, i.e. to the plaintiff's cause of action. Does it refer only to acts or omissions which are in breach of a common law or statutory duty of care? That's to say, delictual situations, or does it include also acts and omissions which are in breach of contractual terms by which the defendant has undertaken not to act negligently? That is to say, a contractual situation. And then you get, essentially what follows is his analysis. And if we just pick it up underneath line 40, he says, having looked at the definition of fault, it follows that no negligence, breach or statutory duty and no other act or omission of the defendant will bring section 3.1 into play unless it's one which gives rise to a liability in tort. In other words, the act applies only when the plaintiff's cause of action is in respect of some act or omission for which the defendant is liable in tort. Conceivably, the defendant may be concurrently liable in tort, but that is immaterial. The sine qua non is conduct creating liability in tort. Well, we would agree with that in the sense of once one is focused on the position of the defendant, it is concerned with creating liability in tort. And then the second limb, he then goes on to, the second limb of the definition of fault he then goes on to deal with is concerned with and is referable only to the conduct of the plaintiff. It relates not to any cause of action, but to conduct which prior to the act would have given rise to the defence of contributory negligence and which is now to be regarded as that conduct on the part of the plaintiff which will lead not to a complete defence but to a reduction in damages. Before the enactment of the Contributory Negligence Act, the defence of contributory negligence was a complete defence in tort. It was not a defence in contract where the issue was more likely to be simply causation. Now, that is curious because we would entirely agree with that as a proposition. It is right, as we've seen from the decision in Astley and Ostrust, that contributory negligence was not a defence in contract. Now, and then if we go over to 6465, you then get the conclusion. Now, the difficulty in our submission with the passage from Mr. Justice Pritchard, which we were just looking at, is it doesn't explain how the Act can apply to a cause of action in contract where, as he accepts, the negligence of the plaintiff is not a defence at common law. And this was essentially the point, I think it was Chief Justice Gleeson's second point in the list of five reasons of critiquing this case were identified. There is, we would suggest, a gap in the reasoning, because having correctly identified that contributory negligence wasn't a defence to a contractual action, he doesn't actually explain how it is that the Act is capable of applying to a cause of action in contract. And related to that, he doesn't explain how the apportionment legislation can apply to a cause of action in contract. So, as I say, whilst we agree with respect with his analysis of the historical position, in our submission, he's fallen into error in not applying that correctly to the terms of the legislation. Now, the decision in Roe and Turner Hopkins did in fact go to the Court of Appeal in New Zealand. And I think if we can just go straight to 6456, they said relatively little on this point.
Do I have that page number again?
It's 6456 of the electronic bundle. And this is the New Zealand Court of Appeal. And they didn't deal with the contributory negligence issue of law in any detail at all. And indeed, it seems by this stage it had largely been dealt with by way of concession, because in the middle of the page, you see there's a passage beginning, it becomes unnecessary to consider the questions of law which Pritchard J examined so fully, and this is just as well. But then he goes on to say, on the Act, it would therefore not be right to do more in this particular case than refer to the view that it can apply wherever negligence is an essential ingredient of the plaintiff's cause of action, whatever the source of the duty in disposing of this appeal on the facts only. We should not necessarily to assent to the narrower view of the Act reached in the judgment under appeal. Now, what they were saying is that they think Mr. Justice Pritchard may actually have construed it too narrowly. And this is going back to the point that my Lord Reid was adverting to earlier. They appear to be saying, well, it's sufficient if you focus on the word negligence, that negligence is an agreement of the cause of action, whether that's a contractual cause of action or a tort cause of action. So in other words, the Act would apply to a negligent breach of contract. Now, in our submission with respect to the New Zealand Court of Appeal, that's erroneous for the reasons we've already explained. When you read the definition of fault, negligence is clearly referring to a negligence which gives rise to a liability in tort. and that's the view which the Australian High Court explained in Astley. But in any event, as I was submitting earlier, the point's a fortiori in the Cayman legislation, because we know how the draftsman changed the definition in 1977 and removed the reference to negligence, referring only to an act creating liability and tort. Now, just to complete the picture in New Zealand, there's then another case called Muat against Clark Boyce, which is at 5352, again in the Court of Appeal. And this was a case of a solicitor who was sued for breach of contract and negligence in tort, as well as for breach of fiduciary duty by a widow who had granted a mortgage over her home as security for a loan being advanced to her son. And one of the issues was whether apportionment was available under the Contributory Negligence Act. The Court of Appeal of New Zealand held that it was, and they essentially gave two reasons. The first is at page 564, on page 5357 of the electronic bundle. And the first reason begins just above line 40 on the right-hand side. This is President Cook, and he refers back to Roe against Turner, Hopkins and Partners, and says that went to appeal. This court, without finding it necessary to decide the point, drew attention to the view, different from that expressed by Pritchard J., that the Act can apply wherever negligence is an essential ingredient of the plaintiff's cause of action, whatever the source of the duty. That is, in fact, my view. While acknowledging that a contrary view can be taken, I would accept the opinion of Professor Glanville-Williams that in the definition of fault, the word negligence is not to be cut down by the later words. And then he refers to the definition. There is an ambiguity that the words other act or omission which gives rise to a liability in tort can be taken to imply that the earlier word negligence is similarly confined to negligence which gives rise to a liability in tort. But he says grammatically that restriction is not essential. Negligence can be read as standing on its own. Now, again, that's the same point. I mean, in our submission, it's A, wrong as a matter of interpretation, but B, in any case, irrelevant to the Cayman legislation. And then if you go over the page, in the second paragraph on page 565 of the report, he provides a second reason. He says, while I prefer that wider view, the result is the same in the present case on the somewhat narrower approach, that the Act applies wherever there is a duty of care, one source of which is the law of tort, no matter whether or not there is another source of contract or otherwise. It is also the same on the view to which I subscribe that at the present day, whenever liability depends on a breach of duty of care, apportionment for contributory negligence is available, even if the Contributory Negligence Act can be considered inapplicable. At the very least, the Act can be used as an analogy in developing the law of negligence. Now, the difficulty with that in our submission is it doesn't explain the basis for that in the construction of the statute. It doesn't deal with the requirement that the fault of the plaintiff must be such as would have given rise to the defence of contributory negligence prior to the operation of the Act. And it's inconsistent with the analysis which the House of Lords explained in the Standard Chartered Bank case, that you need to ask yourself whether contributory negligence is a defence to the action that's been asserted. If we remember that the Standard Chartered Bank case, the House of Lords looked at the question, they were faced with an action in deceit. They asked themselves, what is contributory negligence a defence to an action in deceit? You don't ask yourself whether it's a defence to some other action that might arise out of the conduct, like an action for negligent misstatement. And the sentence at the very end, just above line 20, it is our submission difficult to understand how one gets anywhere by using the Act as an analogy in developing the law of negligence. As we submitted at the start, the ability to apportion is a statutory power, and its confines and scope are circumscribed by the terms of the legislation. But I think one can see there is a variety of approaches. I mean, the position in New Zealand, I think, is probably somewhat different, and potentially in the other direction to the position in England as per Vester and Butcher. On the other limb, you've got the decision of the Australian High Court in Astley and Austrust. So I was then going to turn to Vester and Butcher, if I may, which is a case, of course, your lordships will be familiar with. The judgment at first instance was obviously given by Mr. Justice Hobhouse. If we go to 4105 of the report, he actually spends a lot of time in the judgment dealing with the facts and questions of liability and so on and so forth. He then gets halfway down page 507 to what he identifies as the question of law. As he says, the plaintiffs say that contributory negligence on their part is no defence to their claim against the brokers. The Law Reform Contributory Negligence Act 1945 has no application to a claim which is or can be made on an allegation of breach of contract. And then if we go over to 508, he deals with the question, first of all, as to whether a decision of Lord Justice Neal in the Marintrans case was binding on him. That was a decision where Lord Justice Neal had said the 1948 Act doesn't apply to contractual claims, and he'd said that's not binding on him. And then he identifies at 508F the passage. Well, he sets out in the passage at 508F that the three categories of case which he has identified. And the question whether the 1945 Act applies to claims brought in contract can arise in a number of classes of case. Three categories can be conveniently identified. And these are what we would now call Vester Category 1, Vester Category 2, and Vester Category 3. So Category 1 is simply where there's a contractual provision that doesn't depend on negligence. Category 2 is a contractual provision that is expressed in terms of taking care, but where there isn't a corresponding tortious duty. And 3 is where the liability in contract is the same as the liability in negligence, independently of the existence of the contract. Now, having set out that categorisation, he then deals with the important Category 3 case, midway down page 509, page 4107 of the bundle. Now, what he says here, interestingly, is the Category 3 question has arisen in very many different types of case, and the answer is treated as so obvious that it passes without any comment. It's commonplace that actions are brought by persons who've suffered personal injuries as a result of the negligence of the person sued, and there is a contractual as well as tortious relationship. In such cases, apportionment of blame is invariably adopted by the court, notwithstanding that the plaintiff could sue in contract as well as in tort. And the case he then refers to is a decision of the Court of Appeal in Sayers against Harlow Urban District Council. Now, we've dealt with Sayers against Urban District Council in our written case. It's a case involving a rather vivid set of facts where a lady got trapped in a public lavatory and then injured herself trying to escape, and there was a divergence of opinion between the judge at first instance and the Court of Appeal as to whether she'd acted reasonably by trying to escape or not. And that was essentially the issue in the case. But what the court didn't do in Sayers was distinguish between the claim in tort and the claim in contract. And it didn't consider whether the 1945 Act could apply to contractual claim. And that, I think the most the respondents can probably say about Sayers is it implicitly assumes that it could apply to the contractual claim. But it doesn't actually debate the point or address the construction of the 1945 Act in any way. Now, he then goes on to deal with the Marintrans case, and that was a decision we also referred to in our written case, where Lord Justice Neal had come to the contrary view and reached the conclusion that the 1945 Act doesn't apply to contractual claims. And then, if we go to 4108, um, 510 between E and F, picking up on the Marintrans case, he says this: I do accept that the Act was not concerned with displacing contractual rights, as is demonstrated by provisos A and B in section 1, subsection 1, but these very provisos contemplate that the Act is capable of application where there is a contractual relationship between the parties, and thus cast doubt on the approach adopted by Lord Justice Neal. Now, he's referring there to the provisos you see in A and B of what is now subsection, well, for our purposes, is subsection 1 of section 8. And perhaps if we can just bring those up quickly so your Lordships can see what I'm referring to. I think 9520. So these are when he refers to the provisos, he's referring to the A and B under the words provided that you see in the middle of the page. Now, in our submission, he's wrong in what he says about the provisos, because the provisos simply make clear that the Act will not override any limitations contained in a contract on liability in tort. So in other words, if you have a contract that seeks to impose a limitation on liability in tort, then the effect of the provisos is that the Contributory Negligence Law Act won't override that contractual limitation on liability. But what it doesn't tell you is that the 1945 Act applies to claims in contract itself, or themselves. So all the provisos are doing effectively saying, well, to the extent you've got a defence under a contract, then that isn't displaced by operation of Section 8.1. It's not saying that Section 8.1 applies to contractual claims. So if we go back to where we were in Vester and Butcher, which I think was 4108, and when he says just above letter F, these very provisos contemplate that the Act is capable of application where there is a contractual relationship between the parties, and thus cast doubt on the approach adopted by Lord Justice Neal. Well, in a very loose sense, that's right, in the sense that the provisos are obviously contemplating contractual limitations on liability and is contemplating that those will be upheld and respected. But what it isn't saying is that the 1945 Act applies to causes of action founded in contract. So we do respectfully submit he's wrong in the conclusion he seeks to draw from the provisos. And then he goes on, and I think this must be the ratio of the decision, to say, I consider that in the present case and in any similar Category 3 case where there's no express contractual provision which defines the parties' rights and liabilities in a different way, apportionment of blame and liability is open to the tribunal. My reasons are twofold. First, I'm bound by the Court of Appeal so to decide in a Category 3 case. Well, that must be a reference to Sayers against Harlow. In my submission, it wasn't and isn't binding on him. It doesn't actually decide the point. At most, you can say is it implicitly assumes that the Act is capable of applying to a cause of action in contract where there's a claim in tort. It doesn't actually deal with the issue. And then his second reason is that he says, second, the correct analysis is that where there is independently of contract a status or common law relationship which exists between the parties and which can then give rise to tortious liabilities which fall to be adjusted in accordance with the 1945 Act, the relevant question in any given case is whether the parties have by their contract varied that position. Now, the difficulty with that, we respectfully suggest, is it assumes what it seeks to prove. I mean, he assumes that the Act does apply to contractual claims in that circumstance, and then says, well, the relevant question is to ask oneself whether the parties have varied the position by the terms of their contract. But with respect, there isn't any basis or reason to start from that assumption. You have to ask yourself, first of all, does the Act apply to contractual claims? If you reach the conclusion it does, you might then go on to consider the question of whether the defence of contributory negligence has somehow been displaced by the terms of the contract. But effectively, he's leaped the essential part of the reasoning in our submission. And the relevant question is whether the Act applies at all to contractual claims. Now, by way of comment, I think what we would submit is perhaps most noteworthy about the judgment of Mr. Justice Hobhouse is it doesn't really analyse the text of the statute at all. If you look at the judgment, although he sets out the text at the top of the page we're just looking at, he doesn't actually seek to construe the legislation. So in terms of the assistance one can get from it as a guide to construction, that is perhaps a little limited. Now, the judgment of Mr. Justice Hobhouse, in particular that tripartite classification, has obviously been very influential, as the Australian High Court observed in Astley and Oztrust. The case did, however, also go to the Court of Appeal in England. And if we can pick that up at 4124, there were three judgments given by the three members of the Court of Appeal. The first was given by Lord Justice O'Connor. And you'll see just between F and G on page 4124, page 866, his approach was that he essentially preferred the construction of the Act which had been given by Mr. Justice Pritchard in the Roe against Turner Hopkins case, which we'd looked at. So he says, with great respect to Neil LJ, and that's a reference to what Lord Justice Neil had said in Marin Trans, I prefer the construction of the Act by Pritchard J, which for practical purposes responds with practical purposes coincides with my own. Now, that construction we respectfully suggest is wrong for the reasons which I've already addressed. In particular, it doesn't deal with the fact that the claim must be in respect of damage caused by the fault of the plaintiff, which is referable to conduct, which gave rise to contributory negligence apart from the Act. He then refers to Sayers against Harlow Urban District Council, which Mr. Justice Hobhouse had also referred to. And again, in my submission, although you can say in relation to that it implicitly assumes the availability of contributory negligence, it doesn't in any way decide or grapple with the point. Certainly doesn't deal with the construction of the 1945 Act. And then we get Lord Justice Neal. Now, Lord Justice Neal's judgment is quite interesting because he'd obviously taken a different position in the Marintrans case, which Mr. Justice Hobhouse had dealt with. And his judgment is slightly curious. If you go to 4133, page 875 of the report, he says this against letter E. For the reasons which I endeavoured to explain in Marintrans, I find difficulty in assenting to the proposition that on its proper construction the Act of 1945 can be applied so as to reduce a plaintiff's claim where action is brought for damages for breach of contract. So, I mean, he seems to be there, we would say rightly, taking the view, well, it's difficult to see how the 1945 Act does apply to contractual claims. He then says, however, I've now had the advantage of reading in draft the judgment of Lord Justice O'Connor and considering again the cases, including in particular Mr. Justice Pritchard in Roe against Turner Hopkins. In the end, I feel bound to concur in the conclusion which O'Connor LJ has reached. Now, it's difficult to, I think I would respectfully submit to take much from that. I mean, he clearly feels some difficulty in the proposition that the Act does apply to contractual claims. Ultimately, he appears to regard himself as having been persuaded by, in particular, Roe against Turner Hopkins. I mean, if that was the position, he was wrong to have been so persuaded. And then the final judgment is simply, it's Sir Roger Ormroyd, who deals with it in a rather different way. And this is at 879, 4137 of the report. Just above letter B, he takes the view, in spite of Mr. Purchas's valiant argument and researches, I remain quite unconvinced that contributory negligence as such at common law had any relevance in a claim in contract. And then he makes actually a similar point to the point the Australian High Court made just above letter C. Had contributory negligence been a defence at common law to a claim for damages for breach of contract, the reports and the textbooks prior to 1945 would have been full of references to it. The context of the Act of 1945 and the language of Section 1, to my mind, make it clear the Act is concerned only with tortious liability. And then he then explains why that's the position. And then the way he then deals with the case on the facts is at letter E, in the paragraph beginning at letter E. And in particular, third sentence in, he says, it might be more accurate to say that the existence of the contract created a degree of proximity between investor and the broker sufficient to give rise on ordinary principles to a duty of care and therefore to a claim in negligence. Now, as we understand that passage, how he actually deals with the case on the facts is to say there isn't a claim in contract, but there is a claim in tort. That sentence appears to be saying, well, it might be more accurate to say that the existence of the contract created a degree of proximity between investor and the broker sufficient to give rise on ordinary principles to a duty of care in tort. And it seems to be on that basis, he then says that contributory negligence on the facts of the case is available. And that's consistent with the preceding two paragraphs where he's obviously explained why contributory negligence doesn't have any relevance to a claim in contract. So he deals with it in a somewhat different way, it seems. He takes the view that contributory negligence isn't relevant to contractual claims, but he effectively finds a way on the facts by saying that the cause of action can be seen, it appears solely as a cause of action in tort, that contributory negligence is available. So, in effect, you've got a variety of different approaches in the Court of Appeal. You've got Lord Justice O'Connor, who essentially follows the reasoning of Pritchard J. in Roe against Turner Hopkins. You've got Lord Justice Neal, who, in my submission, it's fair to say, I think, plainly felt some discomfort with saying that contributory negligence applies to contractual claims. And then you've got Sir Roger Ormroyd, who seems to take the view that it doesn't apply to contractual claims, but nevertheless there is this route by analysing the way the claim arises on the facts of that case to say that contributory negligence is applicable. Now, I mean, ultimately, we go back to the question of construction of Section 8.1. And in our submission, as we were explaining earlier, the key question is simply whether, prior to the 1964 law, contributory negligence of the plaintiff would have been a defence to a claim for breach of contract against the defendant. It seems to be common ground between the parties that prior to the 1964 law, contributory negligence of the plaintiff would not have been a defence to a pure claim for breach of contract. But there is some suggestion in the respondent's case that they say the position was or might be different in the case of concurrent liability in contract and tort. Now, in our submission, that's wrong. I've already showed you Astley and Oztrust, which was a case of concurrent liability in contract and tort. That dealt with the availability of contributory negligence as a defence at common law. It dealt with the work of Professor Glanville-Williams, which is the principal matter relied on the respondents. And the respondents don't, as far as we can see, advance any argument or analysis as to why the analysis of the Australian High Court on this point is wrong. The other material we'd refer to on this point in support of the Australian High Court is an article by Professor Goudkamp of Oxford University, who's one of the academics who's written quite a lot in the area of contributory negligence. If you go to 10153,
I'm sorry, which page?
10153. This is part of an article he wrote in the Lloyd's Maritime and Commercial Law Quarterly. And just picking it up on the final paragraph on that page, second sentence, almost without exception, it's thought that the contributory negligence doctrine did not apply to proceedings for breach of contract at common law. And then if you look at footnote 55, he refers to Sir Roger Ormroyd Investor, which we looked at. He refers to the Law Commission report, which we've also cited in our written case. And he refers to Astley and Oztrust. And then he also refers to Professor Burrows, as he then was. And the sole exception is Professor Glanville-Williams in the 1951 thesis. Just picking it up here, going back to the text, it's interesting to note he also takes the view that if you apply the logic of the Standard Chartered Bank case, then it must follow that the 1945 Act does not apply to claims for breach of contract. He says it follows inexorably on the logic endorsed in Standard Chartered Bank and Pritchard, which was a Court of Appeal case concerned with battery, that the 1945 Act does not apply to such proceedings. Put differently, because the 1945 Act extends only to actions to which the contributory negligence doctrine extended at common law. And as, according to the clear weight of opinion, proceedings in breach of contract are not among those actions, the 1945 Act cannot apply to contractual claims. Now, just to pick up a couple of points made in the respondent's case, written case at 2361. This is paragraph 17. They say, although the availability of contributory negligence as a defence in Category 3 cases is ultimately not the critical question, there is support for this view in the following. One, the Glanville-Williams essay, well, I've dealt with that. That is effectively the outlier amongst all the views. Secondly, the railway and banking cases referred to by Lord Justice O'Connor. Now, we don't ultimately, I think, disagree with what the respondents say about these, because they themselves accept that those cases don't specify whether the relationship was contractual or tortious. If you look at the cases, they simply approach the question of liability on the basis that there was, quote, negligence, unquote. And they don't make any reference to the possibility of concurrent liability in contract. I mean, what you can say about them, perhaps, is that there might well have been concurrent liability in contract, but that is not a point that is actually adverted to on the face of the judgments at all. They simply refer to liability in negligence. They certainly don't establish that contributory negligence is a defence to a contractual claim. They do not say that at all. And then the other case is a case called London Joint Stock Bank against Macmillan. In our submission, this case doesn't assist at all. It's a banking case. The case simply holds that as part of the contract between a customer and a bank, the customer will take reasonable precautions when executing a cheque so as not to facilitate forgery. So as part of that contractual duty, there is a duty on the customer to act with reasonable care not to facilitate forgery. If the customer then breaches that duty, he can't recover damages against the bank for breach of mandating and cashing the cheque. But that isn't as a result of contributory negligence. It's a matter of causation, because one says, well, actually, the loss was caused by the customer's breach of duty and not the bank's. And in fact, that point goes back to a point Mr. Justice Pritchard made, that in contract cases, the issue normally isn't one of contributory negligence, it normally was one of causation. Final point is we also rely on the fact, as I've already commented, that Mr. Justice Pritchard, as well as the Australian High Court, and as well as Sir Roger Ormroyd, were of the view that defence of contributory negligence wasn't a defence in contract. My Lord, I'm conscious of the time.
I have let you go on beyond 1 o'clock to finish the point. But,
thank you very much. I'm much obliged. That's a very convenient moment. I'm grateful. Thank you.
Very well. We'll resume at 2 o'clock.